Now it's my privilege to introduce Dan Harris, author of The Trojan Bourse, which explores how pressure is exerted to achieve the divestment and exclusion of certain stocks from investment portfolios. Dan Harris has been advising legal financial institutions, supranational organizations, governments, NGOs, multinationals, and asset management firms operating in the secondary securities and derivatives markets for over 25 years. He's counsel to many of the world's systematically important financial institutions, advising on their high-value trades with idiosyncratic risks, and he leads the ESG boycotts and sanctions desk at Chancery Advisors, navigating opportunities and risks attached to exclusions, divestments, and sanctions. He's also author of leading peer-reviewed academic articles, including A Pox on the Pax ESG, discussing the unforeseen risks attached to ESG policies, and he's featured in the Financial Times and City AM on ESG matters. The Trojan Bourse sets out a new and comprehensive framework for analysis of the conduct of the BDS movement against Israel in and around the global securities markets. It examines the distinctive character of BDS in the securities markets by reference to case studies, and it explains how the movement engages financial regulation separately and distinctly from the political activities of BDS. The foreword notes the Trojan Bourse exposes the BDS movement's manipulation of the securities markets, which are the foundation of our economy, and this treatise is therefore a valuable warning for regulators, legislators, and investors of what is a live and developing problem. Ladies and gentlemen, please put your questions to our speaker into the Q&A facility for the post-presentation discussion. Dan, thank you so much for joining us. Dan, you're on mute in time-old fashion.
Sorry, thank you, Natasha. Thank you for hosting, and thank you, UKLFI Charitable Trust, for your wonderful educational programme. And good evening, everyone, and good afternoon to those in the US. I propose to run through a few slides and then open it up to questions. This presentation is slightly different to some others in that it's not reporting on an historical event or a case that's been closed. This is very much a snapshot of a moving picture. So I'm sure if this presentation was given in a year's time, the content would be very different. So hopefully you can see the PowerPoint. So I just wanted to start off with a simple table to set the scene. It's a slight oversimplification, but it makes an important point. The point really is that BDS is not monolithic. It takes different forms in different settings and contexts, nor is it a grassroots organization, as we've been led to believe. Certainly in the financial markets, it's initiated and run completely by professionals. So the left-hand column is Main Street. So this is the world that we all live in, where we see visible evidence of BDS, placards and protests on street corners and outside shops. On the right-hand side, Wall Street, BDS is less visible because buying and selling an intangible share doesn't necessarily make the headlines and is not identifiable to everyone. In terms of regulation, I think it's fair to say that on Main Street in the real world, there is very light regulation. A BDS protest can be undertaken on the street, and provided no public order offences are committed, then the police will allow people to protest and hold up their placards. In the financial markets, the situation is very different. They're heavily regulated. Dissemination of false or misleading information is something that regulators are extremely focused on. So in that respect, freedom of expression is a qualified right in the markets. Thirdly, BDS activists in the real world tend to act for themselves. They are self-motivated. If they want to stand outside a shop on a rainy afternoon in Brighton and hold up a placard, then they can. In the financial markets, you tend to find that the actors are agents. They're acting as fiduciaries. In other words, they are undertaking to manage money for other people on the basis of a relationship of trust and confidence. And that's important because they're held to a higher standard. Fourthly, as I mentioned, BDS takes the form of a visible protest on the streets or by aging rock stars trying to stay relevant. In the financial markets, again, the regulation is such that it's not for agents or fiduciaries, investment managers, to protest using other people's money. What this really means is that a decision maker must focus on the purpose for which a power to act has been given, rather than simply exercising their power as he or she sees fit. So, for example, exercising a power on the basis of your own moral political beliefs is not appropriate, at least in many circumstances. So these are just some less familiar images of BDS. So on the left-hand side, we can see two pensioners, and these are really at the center of this activity. Investment managers managing pension funds, NGOs targeting pension funds, end up actually using these people's money to pursue their political agendas. And often these pensioners know very little about the actual issue or how their money is being used. So it's worth bearing that in mind, and I think that for a regulator, it's important to understand that there are real people whose money is being used to pursue this activity, because ultimately regulators are in place to protect consumers. So just a little bit about the financial markets for those less familiar. So we're all exposed to the financial markets. Usually that's indirectly. So our banks, our utility companies, our insurance companies, and our pensions are all trading on a daily basis in the financial markets. It was almost 100 years ago in 1929 with the stock market crash in the US that highlighted to regulators in the US just how important the financial markets are to the national public interest. And that led to significant legislation in the US, which remains in place to this day. And to some extent, regulation in all developed markets feeds from this, this first legislative step. So many factors may or may not affect the markets. There are some wars, for example, that can affect the markets, and there are some wars that are simply shrugged off by the markets. But there is one golden rule, and that is that markets will collapse or be negatively affected where market integrity is undermined. Because when this goes, confidence evaporates. And as I say at the bottom, when that goes, liquidity goes, people stop trading, and then we certainly all feel it on Main Street in our pensions and in our investments. So what does financial regulation look like? Obviously, it's complex and covers a lot of areas, but at its heart, it's seeking to protect consumers and to protect market integrity. So in the context in which we're discussing this, for example, the manipulation or attempted manipulation of financial instruments can consist of disseminating false or misleading information. It can consist of the invention of manifestly false information, but also the omission of material facts, as well as knowingly inaccurately reporting information. The FCA, along with other regulators, requires that those it regulates manage their conflicts of interest, they act in their clients' best interests, they conduct their business with due skill, care and diligence, which is difficult to conclude that some investment managers are doing if they're reliant on false and biased information from various NGOs in this area. And for certain regulated funds in the UK, funds obviously have to make a disclosure of the risks to investors. And if they seek to exclude an entire sector, which they would otherwise be authorized to invest in, they need to disclose that as well. So a blanket exclusion might be very difficult for investment managers to make without formal notification to investors. And then turning to market integrity on this slide here, it's critical that the regulators are enforcing the highest standards of those that are managing other people's money. And it's for that reason that the number one priority for regulators is to guard against market manipulation in all its forms. And we think of market manipulation as insider dealing, but it's much more than that. Now, typically, market manipulation is clandestine because the actor seeks to make a profit or some financial advantage and gain an edge on its competitors. But as you know, we live in a topsy-turvy world where some companies are valued in the billions of dollars, despite making no money and having no prospect for making any money. So it's no surprise that in this particular context, what we're seeing is some form of attempted market manipulation, but in plain sight, under our noses, and for no particular financial advantage. So the BDS actors don't seek to gain any particular financial edge. They just seek to impose damage or gain a political advantage. And it's that feature which makes it slightly different and why regulators need to start understanding what market manipulation may look like in 2022. So the question is, if you're an NGO and you have a particular political grievance, whether it's BDS or some other political agenda, in the past, you would stand with your placard on the street in the rain, hoping that some people would take notice, and they may or may not do so. But now we're in a different world where BDS and their political agendas are able to be injected directly into the financial markets and weaponized. And the way they can do this is through ESG. So that's the explicit inclusion by asset managers of ESG risks and opportunities into traditional financial analysis and investment decisions. So the idea that investment managers can consider non-financial factors in certain circumstances has been interpreted by many NGOs and many political activists as a means by which they can convert their political agendas into action by causing divestments or exclusions. So it's a weaponization of their political agendas. And in England, they've been encouraged by fairly recent clarification in the common law as to the parameters for the inclusion of non-financial factors into investment decisions. The US, which I should mention, as there's many US attendees on this call, is slightly more complicated in that ESG has not been fully embraced as something, as a tool in the financial markets. It's still undergoing significant debate in the US. So split between Republican and Democrat lines. On the left-hand side, obviously in red, there was guidance from the Department of Labor in connection with retirement funds in the Trump administration. that basically said that fiduciaries of retirement plans could not value ESG components solely to pursue a non-economic or political agenda, but they must focus on economic factors. So in short, profit first. There's a proposed rule from the Department of Labour under the Biden administration to soften that somewhat. So there is some, the direction of travel is clear. On the other hand, here are some screenshots of recent news articles and information. You can see that there is significant pushback from some states. So on the left-hand column, both Texas and Florida are pushing back on boycotts of fossil fuel companies. On the top right-hand side, the Wall Street Journal, some GOP states push back against ESG. So you can see that there's a live debate happening in the States, and that may explain to some extent why BDS activity is more prevalent in the financial markets in Europe than it is in the US at the moment. And then, of course, we've got Elon Musk, who has said that ESG is a scam, and I don't know how many people follow him on Twitter, but it's a few. So there's two ways to look at ESG, either as a risk or an opportunity. So from a risk point of view, it's clear that regulators want to support its development, particularly when it comes to environmental activity. But they do see real risk in the implementation. So if you think about most investment managers, they are geared to analyze financial risk in the traditional way. And they're around for many years before ESG became an acronym. So when it comes to incorporating ESG kind of non-financial considerations into their investment decisions, they have to outsource. They don't have the skills in-house. Therein lies the problem, because often the third-party analyses are low quality or biased or contain false information. And investment managers simply or quite often don't look past this analysis, they just purchase it and then act on it. So there is risk that biased information is making its way into investment decisions, which affect pensioners. Thirdly, as I'm sure you've heard about ratings agencies recently in connection with Morningstar, ratings agencies provide ESG ratings products. So they score particular stocks or particular companies with an ESG score. The European regulator ESMA has described this particular aspect of the market as immature. And as I'm sure you've seen in the press, there are issues in the US in connection with Morningstar and its view on Israeli and other stocks linked to Israel. And despite steps to create some kind of global European taxonomy in connection with environmental considerations, there's no global taxonomy, and certainly no global taxonomy when it comes to S or G. So there's no common standards. So to some extent, one investment manager may make a decision based on a set of facts, and another investment manager may make the opposite decision based on the same set of facts. So there's a lot of room for interpretation here. And this interpretation is fueled by English law, where the incorporation of ESG factors is basically a function of the common law, leaving significant room for interpretation, which I can get onto in a second. So these risks are real, but for BDS activists, they're an opportunity. So investment managers' appetite for external ESG data is rapacious. They simply cannot produce this information and research in-house. So NGOs, certain UN bodies, which you're familiar with, and unions are incentivized to miraculously reinvent themselves as research analysts. And there is a risk that the information they produce is laced with bias or misinformation, or overweights some information and underweights other information. Investment managers often pay little or no consideration to the underlying facts or the law. There's near total reliance on information that they obtain from third parties, and often blind acceptance. And the reason for that is they're paying for this information, so they expect it to be correct. Thirdly, there is a trend, as we've seen many times now, for investment managers to engage in virtual signaling so they can demonstrate their ESG credentials. And often they pick stocks which they think are easy to exclude because they represent a tiny proportion of their portfolios. So they can virtual signal at the same time as not impacting their particular portfolios. The clarification by the Law Commission in the UK, followed by a rubber stamping of the particular ESG test by the UK Supreme Court, has essentially given BDS activists a blueprint of what they need to do to inject BDS into the markets. And thirdly, there is significant herd mentality in the market. So it's always been understood that when it comes to trading stocks, buying and selling, there is a herd mentality to some degree. But with an ESG overlay, there's significant herd mentality simply because without any taxonomy or global standards, the only way that an investment manager can really decide whether to exclude or divest a stock is to see what others have done. So it becomes self-fulfilling, where if one manager does something, there's a risk that another manager will simply follow suit without exercising their own judgment on that particular issue. So the bottom line, as I put there, is that ESG is opens the door to the markets for those seeking to pursue political agendas. So to them it's a gateway, and for investment managers receiving that information, ESG provides an import license to allow them to consider non-financial information. So I'll just run through a few case studies very briefly without going into too much detail. The first is Unison. So Unison, for those not familiar with it, is the UK's largest trade union with more than 1.3 million members. They have issued twice now a document entitled, "Is your pension fund investing in the occupation?" And that's overlaid on a cover with a picture of the concrete section of the separation wall, which is designed to convey an image of containment and a bleak outlook for those on one side of it, which is designed to elicit from its members an emotional response rather than an informed response. The question itself is clearly loaded. They're skipping over the issue as to whether there is an occupation and whether that's the proper characterization of it. And then the document itself frames the issue in human rights terms, not as a political dispute. And it's seeking to persuade its members to advance its political agenda. Now, in the old days, if you had a particular political view, you would convey it, and some people may listen to it, some people may not. Unison goes a step further, and it holds the pen of its members. So you can see on the right-hand side, it's drafted a model letter. So having issued the document, it then has drafted the letter for members to copy and paste and sign and send to their pension funds saying you should divest from this stock or that stock. So it's quite an aggressive approach in that Unison is not acting as the agent of its members, rather is acting as the puppet master and requiring its agents to, its members to act as its agents. The next case is the UN database, which I'm sure you're familiar with and doesn't need too much introduction, but it contains a list of businesses that they say are involved in certain specified activities related to Israeli settlements. The key thing to point out here is that it does not offer a legal conclusion. The facts and the evidence were sourced from biased NGOs, and it relies critically, on the last bullet point, on clever word usage. There's a difference between human rights concerns and human rights breaches. It doesn't go so far as to say there's been human rights breaches, but it says more than enough to fit within many ESG policies, which presumably mention human rights in a vague way. So it's very easy for investment managers to think, okay, well, this is a UN document, it mentions human rights concerns. My ESG policy mentions human rights breaches, maybe the two are the same. This is aggravated by the following, if you can see, I apologize, it's small writing. There's a number of ways that investment managers incorporate ESG factors. So if you look at the second item, positive best-in-class screening. So about $1.8 trillion worth of investable assets that are focused on ESG use this strategy. So in essence, the investment manager analyzes companies and decides which is the best in class and then decides to positively invest. But that number is dwarfed by the top number, 19.8 trillion. So most of the world are using negative exclusion screening. And there's a reason for this. Investment managers want to easily operationalize their ESG policies. They want a cheap way of doing it. So the purchasing of a list, which they can simply run against their portfolio and exclude this stock or that stock, is the easiest thing for them to do. So the UN list is designed with that in mind, to create a list which they can then just run against their portfolios. Now, of course, the problem with a list is that it excludes nuance. It's binary. You're either on the list or you're not. And there are very few stocks in the world that should definitely be excluded. Even if you look at stocks like tobacco, there have been tobacco companies that have repurposed some of their subsidiaries for COVID-19 research. So you can already see that there's a debate as to whether that particular stock should be excluded or not, because nothing is clear cut. So the idea that companies caught up in a political dispute should appear on the list definitely excludes nuance, and that works to the BDS movement's advantage. The third case is in New Zealand. So the New Zealand Superannuation Fund is a sovereign wealth fund owned by the government of New Zealand, but managed independently. It recently excluded 5 Israeli banks. This was not a financial decision. It was part of their responsible investment policy. As you can see, there's a clear argument that it may have misdirected itself in a number of ways. It considered irrelevant factors. It was quite focused on the announcement a few years ago that there could be an annexation of the West Bank. Despite this fact becoming less and less likely, despite a change in Prime Minister and despite the Abraham Accords, and yet they put considerable weight on that. They also focused on another fund that had excluded stocks called PGGM, and ignored the fact that PGM had subsequently reinvested in those stocks. So again, overweighted some factors. It ignored the fact that there are thousands of funds out there that do invest in these stocks. And it applied the wrong internal test for exclusion. It said that it would exclude stocks where there was an unacceptable risk that the banks are contributing to the breach of human rights. But this test does not appear in their own policies. And it only applies as a fallback where there's no available evidence. but they made a conscious decision not to engage with the companies or look behind the UN list. So if you create the situation where you have no evidence because you don't look for it, it's difficult to see how the fallback test would even apply. So that's another case. The last case is KLP, which is a very large Norwegian financial conglomerate. It excluded 16 stocks. In this case, there was a worrying sign that there was a lack of probity. So it was identified that someone, a senior analyst at KLP, responsible for responsible investment strategy, had put quite a bit of anti-Israel information on her Twitter feed, which they took screenshots of. When this was identified, as you can see at the top, she briefly cancelled her account, and I think it's now live again but locked. The issue here is that there's a clear argument, there's a conflict of interest, and this is one of those phrases that's bandied about, but it is not an abstract concept. The risk with a conflict of interest is that it leads to a risk that where there are contraindications or a suspicion of a truth, then the investment intermediary does not want to know and refuses to investigate. So this results in a blinkered view which skews outcomes, in this case, creating exclusions. And ultimately, that decision is paid for by real pensioners. So the next question is, who does it impact? So the BDS movement, we know the state that it's targeting, but there are a number of possible entities or persons that can be impacted by this activity. So the first two, the target company itself, well, maybe it could be that the impact is nothing more than irritation, because it raised its money in the stock market with its IPO, and then subsequently its shares are trading in the secondary market. So buying and selling those shares doesn't create new finance for the company. So it may or may not be affected. The third category, pensioners and other investors, well, yes, they could be affected. The investment manager could be affected if it's breached any rules. It could be affected negatively with its regulator. And of course, damaging a company can affect Palestinian workers, who I guess the PDS movement regard as collateral damage. So it's clear that there's a number of possible victims, but every case is different. The one constant, though, is the bottom one, which is the integrity of the markets. There's no doubt about it that to some degree or another, the integrity of the market is being affected. If false or misleading information is being disseminated and trickery is being used for it to be acted on, or at least negligence, then shares are being sold or excluded on a completely false basis. So in more detail there, disseminating or excluding false or misleading information, trickery to have it acted on, investment managers are often in breach of their duties, and we don't need to look into fiduciary duties. Often that is just basic negligence if they don't perform due diligence on the information that they're relying on. And of course, consumers not adequately protected if their pensions are impacted because someone decided that their pension should divest of a particular stock. So to bring it back to the title of the book, the way I see it is that the financial markets are a little bit like Troy in that they're encircled by a protective wall, in this case regulation and piecemeal laws. But there is a way through, and so BDS activists create a package of false or misleading information and effectively leave it at the gates. And it finds a way in through ESG, through investment manager policies adopting ESG, through investment manager negligence, and through investment manager conflicts of interests, etc., etc. So once it makes its way into the citadel and that information is acted on, then stocks are divested or excluded from portfolios. And it's that allows BDS to turn from a political agenda to real action and weaponization. Undoubtedly, to some degree or other, this undermines the integrity of the markets. So that is something that I think regulators need to focus on. So turning to regulators, we have to understand what their role is. Their role is not to get involved in political disputes. But from a regulatory point of view, this is not a political issue. This is a regulatory issue involving market integrity and protection of consumers. The regulators are already focused on a lot of these issues. So only 2 weeks ago, or sorry, a bit longer, about a month ago, the FCA wrote to many of its regulated firms saying, we're focused on conflicts of interest. Poor management of conflicted positions can encourage market manipulation or improper fund performance reporting, in turn producing poor consumer outcomes and a loss of market integrity, which is precisely what we've been saying on this call. Again, they say market abuse undermines confidence in and the integrity of the financial markets. Established robust systems and controls are crucial in mitigating this risk, with firms providing a vital first line of defense. So it's clear that regulators are focused on exactly the same issues we are. It may be they just haven't joined the dots and seen that this occurs in a BDS context rather than in the context of seeking to find a financial edge. So it's important that in our day-to-day lives, if we see this kind of activity, that we make financial regulators are aware of it so they can become more informed. And that could be weaknesses and shortcomings in ESG ratings providers. It could be lax judgment by investment managers, or it could be the dissemination of false or misleading information. So I think that this is a work in progress, and I think that there's another step for this to go where regulators need to understand this is not a political issue from their point of view. It is, of course, in the real world, but from their point of view, it's a financial regulatory issue. So there's more to come on that front, I think. And that's it, Natasha. So back to you.
Dan, thank you ever so much for that overview. This is clearly an area which is in its infancy and will doubtless develop. You've referenced the United States a few times in the context of this topic, and you've also made reference, a few references to Morningstar, which got into difficulties when it acquired Sustainalytics and subsequently had to cut ties with Human Rights Radar due to concerns over bias. Could you perhaps start off our discussion by describing what led to that controversy and what this might mean for future developments?
Yes, so you're right, it relates to ESG ratings products. So as I mentioned, many asset managers rely on ESG ratings products to make investment decisions. And as a result, these companies stand in an incredibly powerful position because they're sitting on the sidelines of the market and they can actually influence securities transactions. So clearly there's a risk generally that they could be overweighting or underweighting certain information or privileging false or misleading information that they've extracted from Google or other media where people, NGOs have posted in particular information. So it's a massive issue and one that financial regulators need to be all over. Morningstar in particular, I guess, as you said, is more accurately described as the Sustainalytics issue. Sustainalytics provides various ESG ratings products, and the issue involves its ESG rating system and allegations that it has an anti-Israel bias. So the first step last year was that it had an independent review conducted by the law firm White & Case. But now the temperature has raised slightly in that there are many state investigations into Sustainalytics rating system, and then 2 weeks ago, I think it's called the State Financial Officers Foundation, which is an association of, I think, Republican attorney generals. I think 18 AGs wrote to Morningstar alleging that ESG ratings products offered by Sustainalytics relied on anti-Israel sources and automatically punished any company involved in the Israeli economy. And they requested corrective action. And I think there's been other communications to Morningstar as well from particular attorney generals. So that's one approach to this problem of ratings agencies, is the direct approach. There's two other ways, I think, to deal with it. The first is regulation. The second is regulation. So the general view amongst European regulators is that some sort of regulation is needed. I like the direct approach, to be honest. The third route is a contractual solution. So given the risks that have been identified, whether in connection with this company or other companies, I think that there's a contractual solution, which is that financial industry bodies should maybe issue a statement of best practice to all their members, suggesting that investors and investment managers actually build into their contracts with ratings providers a set of representation and warranties to give them comfort that the ratings agency is not conflicted, it's managing its conflicts of interest, it's doing due diligence on its sources, that kind of thing. So I think the US direct approach will obviously reap some rewards. Regulation and contractual solution are probably the way to go. But you're right to raise it, because it's, I think, the number one issue in this space and something that regulators are focused on.
We've had a lot of questions coming in. Quite a number of them go to the potential solutions to the issues you've raised, and you've started to address those with respect to the direct approach, regulation, contractual solution. In terms of the responsibility of individual account managers, well, first, could you just answer a direct question from a member of the audience who wishes to know the UK Supreme Court case that you referred to following the Law Commission report on fiduciary duties? Do you know the reference?
A case involving the Palestine Solidarity Campaign.
Right.
Which, if you type that into Google with Supreme Court, it will come up.
The very same that has led to a lot of the discussion over potential legislation with respect to BDS, which is certainly awaited. In that case, I'm sure we can circulate a link to that case in the chat in due course. I shall have a Google for it. Are you able to also talk about potential solutions in the context of investment managers being held accountable for their decisions if influenced by inappropriate considerations?
Well, investment managers, they're acting for underlying investors, but between the investors and the investment manager is some kind of fund vehicle, and so they contract with that fund vehicle, and normally that has an independent board. So I think that directors of those independent boards should be made aware of these issues and should hold those investment managers to account, because it's likely that they could be breaching their own ESG policies or the contractual terms under which they're mandated. And so there probably is some scope there to complain to the investment managers beyond raising a regulatory issue. And I think that that hasn't really happened so far, but that is the job of independent boards or funds. So I think that the lawyers on this call, of which I'm sure there are many, could maybe focus on that with their clients.
I'm sure this question has come from a lawyer who asks, is there any value in bringing a class action suit against BDS perpetrators founded on market manipulation claims, even though this individual accepts these cases normally initiated by a regulator? Do you see any wider scope for other parties to pick up the mantle?
I'm not a litigator, and it's difficult to answer, but I think the starting point is probably to make this issue more visible to regulators, because class actions are obviously one thing, but regulators have their own enforcement powers as well. And so whether or not a particular decision has affected an investor doesn't mean to say that the investment manager hasn't necessarily breached a regulatory duty. So I think there probably is scope on the regulatory front, and investment managers, their number one consideration is making sure they don't fall foul of their regulators, because without that they can't do business. So yeah, I think probably, you know, with class actions, we tend to take our lead from the States, and that's where there's often more scope for that kind of litigation. So I guess we will watch this space, but I think part of our role is to get this information out there more than it is already. And at the moment, you know, everyone is aware of certain discrete activities, spreading false or misleading information, or someone making a decision based on flawed ESG issues. But actually everything is linked. They've made that decision based on that information. And so it needs a regulator to have an oversight of everything. And I think that's probably the way forward.
The case that you were referring to, Aaron's Secretary of State for Housing, Communities and Local Government, ex parte Palestine Solidarity Campaign, is now linked in the chat for anyone who does want to see a copy of the judgment. Dan, I'd like to pick up on your reference to herd mentality, and in particular, the difficulty of perhaps drawing a line if and when these the impact of BDS on the financial performance of certain companies actually comes to be felt. How it's possible to draw the line between the divestment for inappropriate reasons, perhaps often based on misinformation, and where that might fade into appropriate divestment decisions that seek to rid themselves of shares in, say, a company that isn't doing very well because of the bad publicity that has been generated by this movement. Do you have any thoughts on how it might be possible to draw that line? And clearly, for the purpose of regulation, lines do need to be drawn if people are going to be held account for market manipulation in this sort of way.
It's difficult, and certainly you're absolutely right to make that distinction. There are many reasons whether the companies, wherever the companies are located in the world, to make investment decisions, whether to buy or sell on financial factors alone. And you know, we don't seek any special treatment in this context, and it's perfectly legitimate for investment managers to divest for financial reasons. Funny enough, you know, many investment managers have a particular mandate to invest in a particular geographical region, and as it happens, or with a certain risk profile. And so MSCI, the index provider, recategorized Israel from an emerging market to a developed market, I think in 2010. So there's actually many good reasons for regular investment managers not taking low risk to invest in Israel, because it's regarded as a developed market, and not having the same kind of risks as emerging markets. So that's a point I think that needs to be made more loudly. You're right. I think there have been cases where investment managers have made decisions based on political reasons, but recharacterize them as financial reasons, and that's an evidential question. And you know, I think regulators have the power, you know, to look into that further and understand exactly what their decision-making process was, looking at their emails and their phone conversations. So, you know, in a significant case, that information can be undone. And if you then say to the market, I divested for financial reasons, when in fact you didn't, then, you know, clearly you're not acting in good faith, which is a whole nother set of problems for that investment manager. So yeah, the line can become blurred and difficult to prove, but you know, often there is evidence there as to how investment managers make decisions. You know, normally they have a meeting on a Monday morning to decide what they're going to do.
Yeah.
So and there are minutes of that. So, you know, it's not beyond the wit of man to find out exactly why a decision was made.
That perhaps leads on to another question here, delving a bit deeper. It asks, is there any data yet on the pure financial performance of funds where ESG includes BDS considerations versus performance of funds without BDS considerations? And is it necessary to show a negative financial impact, or instead rely on the dangers of market manipulation and abuse? And that ultimately comes down to the question of quantifying what it is that we're talking about, doesn't it?
I'm not aware of any data. I think that if we could look into the future and forecast, I think by disseminating this information to 1.3 million people, for example, and putting it on the internet for more people to look at, clearly the intention of those who create this information is not for it to be used in a narrow sense, but for the market to adopt it widely. And so often I think we're in a position where there's attempted market manipulation, which is you know, just as bad and illegal as actual market manipulation. So I think we're in that phase a lot of the time. I'm not aware of any data. But I don't think the data is necessarily critical because with market abuse, it's not always a case you need to demonstrate that the actor has made a profit. So I think it's more about their conduct than it is about the profit or the damage that's caused.
I've got two perhaps related questions to do with pensions funds primarily. The first asks, what are the obligations of pension trustees to their members? And second, can investors sue pension plans or investment managers for breach of fiduciary duty? This is a questioner from the US, evidently. As they say, given that US law requires managers to make decisions based on financial grounds only. Appreciate there is a difference jurisdictionally. What do you see as the obligations of pensions trustees to their members, and likewise investors in pensions funds? What are their options for any breaches of that fiduciary duty?
Well, I think the most helpful answer is not to be too jurisdiction specific, but I would say that I think things are in flux in the US to make it more specific to the questioner, because the Trump era guidance from the Department of Labor is still on the books, but I believe, unless I'm mistaken, that the Department of Labor said we're not going to enforce it. So it's a bit of an odd situation in that investment managers can't plow into ESG. On the other hand, if they do, it's not clear that there will be any consequences for them from a regulatory point of view. But in terms of investors taking action, I don't know the answer. But again, I think that the first step is to make this activity more public than it is, because I think for most investors, they're simply not aware that this activity takes place. And if they're told that this activity is immaterial to the size of the fund, then I'm sure a lot of investors will think, well, okay, that's my number one focus. If I'm going to receive my pension when it's due, then that's all I care about. But of course, a regulator cares about it from a different perspective. So I think it's worth making people aware just of what's going on. And if that leads to lawsuits in the US, then I guess we'll watch with interest, but I don't know what the outcome would be.
Well, picking up directly on that, clearly there are some investors in the audience that do wish to be better informed. And the question is, for private investors on TASE, what is the best source of information about interference by BDS and similar campaigns that may inform investment risk assessment? Do you know if there's any way of discovering any informational data on this? It may be that it's simply not covered, Dan, yet. This is an area that needs to be better analysed.
I think so, and obviously, if a particular company is targeted, it's not something they necessarily want to publicise themselves. But the investment managers often do want to publicize it, sometimes to demonstrate their ESG credentials and sometimes to encourage others to follow suit. So the New Zealand example, they purported to follow suit based on what another investment manager had done, but they also said in their minutes, we expect others to be interested in the decision we've made. So they're encouraging further activity. So it's a question of just following the news really to see what they're doing, but more often than not, they can't help themselves and they do want to publicize it.
So perhaps the organisations promoting it are often the best source of, and indeed that we saw that play out with the Ben and Jerry's Unilever fiasco.
Yeah.
A couple of questions on perhaps future regulation and legislation. One asks, since anti-Israel bias pervades European governments, can we be comfortable that a regulatory approach will be effective?
I see this as complementary. Clearly, there's work to be done by legislatures, and some governments are more focused than others. But I see the regulatory angle as complementary. So up to this point, regulators have been hesitant to engage in what they see as political disputes or disputes between two categories of people, because it's not their job to arbitrate. But I think we need to recharacterize that and identify for them that this is not a political dispute from their point of view, but a regulatory issue. And so when you change the narrative from political dispute to a risk to market integrity, it's not that they should be interested, they're obliged to be interested from that point. So I see it as, I don't see them necessarily as the entire solution, because this is not addressing in any way aging rock stars, that spout about BDS or other BDS activity. This is just in a connection with the securities markets where that's the regulator's domain and they should take more of an interest.
Perhaps a final question here, and I'm sorry we're not going to get through all of them, and it's to do with anti-boycott and discrimination laws at state level in the US. We've had previous webinars on this. I appreciate it's not entirely your area, but the question asks whether they worked in the BDS case involving Ben & Jerry's and Unilever, or whether additional legislation is warranted. And the reason I do put it to you is because you may be able to address how state level BDS legislation is in fact separate from the regulation framework that you've been talking about. And it strikes me that it's the regulation framework that may have been far more significant more recently in the Ben & Jerry's fiasco than the actual state level legislation there and what is anticipated in the UK in short order.
Well, in 1 minute, I think that the state legislation is extremely important and not something that can easily be replicated in many European countries. So we're all grateful for it because if nothing else, it creates a lot of negative noise for Unilever. Ironically, there is actually an ESG angle in the UK in that clearly there are significant questions over Unilever's governance of its own subsidiary. And so we're in the G section of ESG. And so many investment managers should be thinking about their investments from a G point of view, given Unilever's kind of inability to manage its own subsidiary effectively. So, I think there is more scope beyond state legislation to look at, Unilever's conduct separate from Ben & Jerry's.
Well, Dan, I'm extremely grateful for your overview and also for something that you argue in the treatise, which is that you say the lens through which a financial regulator views such conduct does not depend on choosing a side, but upon its impact or potential impact on the integrity of markets. It is apolitical. What especially matters to a financial regulator mandated with protecting the integrity of the markets is whether conduct is isolated or professionally orchestrated coordinated and leaves people acting in concert. And it really has been the theme, I think, of your presentation, that integrity of the markets is paramount, and that aside from certainly all of the additional questions that have focused specifically on the impact of the BDS movement, it's the integrity of the markets that ought to be driving proper regulation of this issue. So I'm tremendously grateful for your overview, and also for the treatise, the Trojan Bourse, which people can find available on Amazon. And thank you for all of the work that you're doing in this area and continuing to write academically on the subject, as well as the day-to-day professional work that you do.
Thank you.
And wishing our audience a very pleasant afternoon and evening wherever they are.